Welcome to all of you. We're very pleased to see you all participate. Whilst you join the meeting, I have a few announcements to make. First of all, I should introduce myself. My name is Jonathan Goldsmith, and I work as a senior project counsel with the European Lawyers Foundation. As a participant, there are a few issues that you need to be aware of. So number one is that you will see at the bottom of your screen a question and answer box, Q&A. Please will you make sure that any questions you have for our speakers are put in the Q&A box. There is also a chat function, as always, as I'm sure you'll be very familiar with in all Zoom webinars. Please do not put the questions in the chat box. They won't be answered. Put the questions in the Q&A mechanism, which is there. We have a large crowd with us today, which is excellent. Please, you're more than welcome to use the chat function to tell us where you're from and to say hello to each other. But as I say, it is important that the questions are put in the Q&A box. As you would have seen, this webinar is being recorded, and you will be able to see a recording of it on the European Lawyers Foundation website in the coming days. And also, all the presentations, you will see our speakers have very excellent presentations with lots of useful information on them. All of the presentation will also be loaded onto the European Lawyers Foundation website. The webinar is in English and no interpretation is provided. I will be stopping the speakers about 5 minutes before the end of their allotted time to allow for questions, and we really encourage you to participate and to ask. For those of you who are using this training also for purposes of your BAR's continuing legal education scheme, please note that we ourselves don't provide certificates, but we will provide the participants list to your BAR if they request it, so that they can then issue you with a certificate. So that is my announcements, and the next phase is for me to introduce with great pleasure the chair of the European Lawyers Foundation's Board of Directors, who is a French lawyer, Dominique Attias, who will give a brief welcoming address. So Dominique, over to you.
Thank you very much, Jonathan. You don't need to tell I am French. You see with my accent. Dear colleagues of all Europe, I see you are from Budapest, Malta, or Cyprus. It's fine. Dear colleagues, it's a pleasure for me to welcome all of you lawyers from across the European Union to this very important webinar about what EU lawyers need to know about the strategic lawsuits against public participation, also known as SLAPPS. While many of you may have heard some talk about SLAPPS, especially when the EU institutions are discussing to the European Commission's proposal for the anti-SLAPP directive, the concept may still be unclear to many. SLAPPS gained their highest prominence after Russian invasion of Ukraine in February 2022, which brought to light that some oligarchs had been using their wealth through a series of lawsuits. SLAPP mainly in the United Kingdom, but not restrict to it as a way of silencing journalists. However, even before that, there was the tragic case of Daphne Caruana Galizia, murdered in Malta in 2017 for her journalistic work and facing over 40 libel suits at the time of her death. Today, we will find out what SLAPPS mean for lawyers. We will begin with a presentation from the European Commission to understand better the current EU legislative effort to combat SLAPPS. Then we will move to an overview of SLAPPS cases in Europe, maybe shining a light on our own jurisdiction with examples of SLAPPS. Next, we will hear about the position of the Council of Bars of Law Society of Europe, CCBE, which is the organization whose members are the national bars and law societies of Europe. And finally, we will understand better the impact of EU lawyers' ethics of the European Commission's recommendation on SLAPPS. I will stop here to allow our incredible speakers, whom I thank for their intervention, to begin to give us all this information in detail. I wish you a very successful event, and thank you, Jonathan.
Thank you very much indeed, Dominique, for your welcome. And so we move straight on to our first substantive session, which is an introduction to the EU anti-SLAPP directive. And we're very pleased to welcome Pia Lindholm, who is Deputy Head of Unit for Civil Justice at the Directorate General for Justice and Consumers at the European Commission. And welcome to you, Pia. And I will now get on screen your slides. So give me a second, and then we will all see them. And you may begin, Pia.
Thank you, Jonathan and Dominic, and thank you for this invitation to present the directive. It's a great pleasure to me. Good morning to everyone, and why I am here is because I'm leading the team which drafted the directive and is currently negotiating the directive, because it's at the moment still only a proposed directive. It hasn't been adopted yet. Actually, this directive was drafted at my dinner table. Well, the first draft, because that was COVID times and we couldn't be in the office. So I'm honored that the first draft was made at my dinner table. So just shortly to introduce you the starting point, why we propose a directive and why now. The trigger was already mentioned by Dominic when she mentioned the murder of Maltese investigative journalist Daphne Caruana Galizia in October 2017. And she, as Dominic mentioned, at the time of her death, she faced numerous SLAPPs, both domestic and cross-border, and both civil and criminal lawsuits. This was the trigger which also raised concerns about the defense for the European democracies. So we concluded that it is important to defend our democracies, rule of law, freedom of expression, and public debate from SLAPPs. SLAPP initiative was actually one of the actions of our European Democracy Action Plan, which was adopted in 2020. So that is when we made the initiative and announced that we will make a legislative proposal on SLAPPs. Just to shortly recall to those who are not so familiar with SLAPPS, that they are groundless and exaggerated court proceedings, typically initiated by powerful natural or legal persons against parties, for example, journalists or human rights defenders, who express criticism against them on a matter of public interest. The aim of SLAPPS is to censor, to intimidate, and silence critics by burdening them with abusive court proceedings. So therefore, we concluded that a robust system of safeguards is needed to enable those involved in public debate to fulfill their crucial role as watchdogs on matters of legitimate public interest. So now to present our package, because this is indeed a package, it is not only the proposed directive. So we proposed it in April 2022, so approximately 2 years after it was announced in 2020 that we will make such a proposal. And we concluded that the most efficient way to fight against SLAPPs and prevent them from growing roots in the EU is a combination of legislation and soft law. So the legislative measures, that is targeted legislation, it is a proposed directive which consists of procedural safeguards against SLAPPs in cross-border civil proceedings. And then the non-legislative part, it's a Commission recommendation. And when it's a Commission recommendation, it means that we adopt it directly. We don't negotiate it with the member states. It's our recommendation to the member states. It complements the legislative instrument by focusing on soft law measures such as training, awareness raising, support to victims of SLAPPs, monitoring. It applies to all proceedings, civil, criminal, administrative. It also applies both to domestic and cross-border proceedings. So the recommendation is a horizontal one. I will explain later why the recommendation, the soft law, can be horizontal and why the legislative measures could only apply to cross-border civil proceedings. This is because of our constraints with the legal basis in the EU. And this package was accompanied by evidence on SLAPPs, which were provided in a staff working document which accompanied this initiative. And just to mention that at the time when we proposed this package, none of the EU member states had SLAPP-specific legislation. 3 member states actually were in the process of preparing such legislation. These member states are Ireland, Malta, and Lithuania, but these have not been adopted yet, and this is largely because, in fact, then the member states, when the Commission proposed EU-wide legislation, decided to wait before they adopted their national legislation. But there were no SLAPP-specific laws in the member states. However, that doesn't mean that there were no safeguards at the time. Obviously, there were certain general safeguards which apply not only to SLAPP, but also to other types of abuse of proceedings in a number of member states. But obviously, these had the handicap that they were not SLAPP specific and they were not aimed to tackle this type of abusive court proceedings against public participation. The next slide, please. So now to present the directive itself, the proposal. So it applies to only cross-border civil and commercial matters. As I mentioned, this is because we have in the EU. We are based on the founding treaties. We need to respect our competencies. So we only could find a proper legal basis for cross-border civil and commercial proceedings. Since we are talking only about cross-border civil and commercial matters, then we needed to see if we need to define matters with cross-border implications. Just to mention that we have a number of civil justice instruments. We don't define cross-border in most of them, with a few exceptions. In this case, we decided to define it because of the specific natures of SLAPPS, to tackle the specific nature of SLAPPS, which even sometimes when they are seemingly domestic, then there are cross-border implications. So we did define that one, but whether there will be in the final directive a definition, that is still under discussion. Another important factor in the proposal is that we needed to carefully balance the procedural safeguards to protect freedom of expression, which was our aim here, but we needed to balance it with access to justice. So we needed to ensure that we are not robbing claimants who have a justified claim from right to access to justice. So again, to underline that the aim was to target the manifestly unfounded and abusive claims and court proceedings, and not justified claims from claimants. It has a broad personal scope, so it covers natural and legal persons, journalists, human rights defenders, and others. Just to tell you that, as I said, the trigger was the murder of Daphne. So in a way, we started from the journalists' concerns regarding SLAPPS. Then we started seeing that there are also others suffering from SLAPPS, human rights defenders. And finally, we concluded that it is not possible to limit the personal scope and say that only these groups can be target to SLAPPS. So we, in the proposal, have a certain narrative about journalists and human rights defenders, but it applies to all natural and legal persons who are targeted by SLAPPS because of their participation in public debate in a matter of public interest. So just to mention other examples of victims of SLAPPS: trade union activists, environmental activists, researchers, and authors. So indeed, we realized that there are many groups which are in fact targeted by SLAPPS. And again, when I mentioned the balance between freedom of expression and access to justice, I want to underline the fact that SLAPPS are not initiated to gain access to justice. They are initiated to harass and silence, so they are abuse of court systems, they are abusive to the defendants. Next slide, please. So now shortly to present the key pillars of the proposed directive. As you see, there are 3 key pillars of protection. Of course, there are other provisions in the directive, but these are the 3 main pillars. And this is actually a quite short instrument. It's only 25 articles, so it's not a huge instrument, but there are the core means of protection. The first pillar is early dismissal of manifestly unfounded court proceedings or claims. And we haven't defined manifestly unfounded. We consider that that is familiar both to national courts, familiar to lawyers, what is manifestly unfounded. Now in the negotiations, the member states wanted first a definition. In the end, we don't have a definition. We just have a short recital stating what is manifestly unfounded, that it is so blatantly clear that there is no ground for court proceedings or the claim. So we have this distinction between manifestly unfounded and abusive court proceedings. We have defined abusive with indicators, and it is not a closed list. It is just a list of typical features of abusive court proceedings. Why we made this distinction between the two? The reason is that if the court proceedings are abusive, you normally need to already examine the claim or the claims, if there are several claims, to identify the abuse, that it is not kind of from the beginning of proceedings and blatantly clear to the court. So then against abusive court proceedings, we proposed remedies, and there are three key remedies. The first is award of cost. This is really benefiting the victim of SLAPP, and this is award of all costs, including full costs of legal representation. Then there is the compensation of damages as a second pillar of remedies. And the third one is more a deterrent than to the victim. It's the penalties, which are meant to be effective, proportionate, and dissuasive. So this is more about the deterrent effect against the claimant. So to kind of prevent them from initiating abusive or manifestly unfounded court proceedings. So these are the three key pillars of remedies. Then as a third pillar, we have the protection against third country SLAPP judgments, because indeed SLAPPs don't know borders. There are international agreements under which the claimants from third countries, first they can initiate a claim in a third country, get a judgment in their favor, and then try to enforce it in the EU. So we have two pillars of protection against that. So if it's an abusive court proceeding, if it's a SLAPP, then the judgment from the third country will not be recognized and enforced in the EU. Then the second pillar is what I called turning the tables, which is a special ground for jurisdiction, and it allows a SLAPP defendant to ask in his or her member state in the EU for compensation of damages and costs in the court of his domicile. So this is a protection, specific protection to any SLAPP defendant domiciled in the EU. The next slide, please. I know that this will be discussed later on what this means from the lawyer's perspective, but I just wanted to stress two issues. Be aware, of course, as you may have realized, on the basis of what type of safeguards there is a key role for courts and judges who actually are then the ones using these safeguards. So basically, the directive is a toolbox for courts and judges to use to tackle SLAPP claims. Of course, also there is a wider factor for lawyers to be aware of the existence of SLAPPs, and then once the directive is adopted, to be, of course, aware of legislation on against SLAPPS. And then in our recommendation, we have a number of measures, awareness raising and training, and some of them are specifically targeted for legal professions. There is still open, as I said, this is only a proposed directive. It hasn't been adopted yet. It is under negotiation still. So there is a possibility of deontological rules for legal professions. They already exist in the Commission recommendation. That is obviously only a recommendation to the member states. However, the European Parliament has made a proposal that there would be a deontological rule also in the proposed directive. This is still a subject to discussion, so like in many respects, I cannot yet tell you what is the final outcome. This hasn't been decided yet. This is still under negotiation between the European Parliament and the Council, which represents our member states. However, just to say that even the rule proposed by the European Parliament, it's a very soft rule. So it's with full respect for the independence of the legal professions. And then it only encourages for the adoption of deontological rules. So it is not a rule imposing something on legal professions. It's rather more for the encouragement. The next slide, please. So now a few words about the next steps, because I have said already several times that this is still at the moment only a proposal. It is still being negotiated between the Parliament and the Council. That's why we don't know in many respects what the final rule will actually be. You can be sure that the main pillars will be there. So it is not about kind of not having the main pillars of protection. However, many of the details are still under discussion. The Parliament has also proposed a number of additional rules also on jurisdiction and applicable law, for example, also incorporating a number of soft law elements in the directive, which are currently in our recommendation. One is deontological rules, but there are also others like data collection and training and awareness raising. But this is still to be seen. However, the ambition at the moment is to reach an agreement by the end of this year. But since this is an EU directive, it still needs to be finalized and adopted after that. That could take place in the spring if all goes well, but this really depends. We're still negotiating, but if all goes well and we reach the ambition of having an agreement by the end of this year, the directive would most likely be adopted in the spring. However, since it is a directive as an instrument, it still needs to be transposed into national law of the member states. We selected directive as an instrument here because these are procedural safeguards which affect member states' civil and procedural law. And since you know that the traditions in civil and procedural law vary between member states, we concluded that it is easiest if the member states can adapt then these safeguards to their own national systems. So that's why this is a directive as an instrument. A transposition period after the adoption of the directive, that is again something still under discussion. The Parliament has proposed 1 year, Commission 2 years, and the member states 3 years. So it will be somewhere in this range. And then finally to mention that the Commission recommendation is directly applicable since its adoption in April 2022, and it is already being implemented at the moment. So thank you for your attention. This was the presentation of the directive.
Thank you so much, Pia, for that excellent presentation. We are very grateful indeed to have heard this directly from the Commission. And there are a couple of questions which I'd be grateful if you could answer. The first question, I think you might have touched on this, but maybe you could give just a bit more detail, is from Julia Radanova, who asks, why would there be an innate need of limiting the directive to cross-border cases?
This is because this is very easy to answer, because substantive civil law is still the competence of member states. We have in the treaties Article 81, which is our legal basis, but this is only legal basis of civil judicial cooperation in cross-border context, and then tackling civil proceedings, kind of constraints for civil proceedings in cross-border context. So this is our role, and that is our legal basis, and that is why we are not able to cover domestic cases. However, we actually tried to customize the concept of cross-border to SLAPP proceedings, which are often by their nature, they are accessible. For example, something a journalist writes is accessible online. So then the journalist can be sued also in other member states than his member state of origin, because if the harm is considered to have occurred in another member state. So we tried in a way to take this into consideration in a broad notion of cross-border.
Very good. Thank you. There are a couple more questions, so if you could just answer each briefly, then we can deal with all of them. Simona Kalapadescu asks, could you provide further details on the criteria that must be met to classify a court proceeding as manifestly unfounded? She believes it's too vague, and member states and judges may be reluctant as a result to classify them as such.
As I mentioned, we didn't consciously set any criteria for manifestly unfounded. However, when we looked into the concept, we considered that national courts are using this concept of manifestly unfounded. Also, the Court of Justice of the European Union has used this concept. However, we couldn't find any definition for that, and we considered that also a definition would be dangerous because it could limit the concept and narrow it down too much. So there is no criteria. As I said, this is a toolbox for judges, and this instrument relies a lot on the judges, and we actually trust on our national judges to know their job and to be able to assess when they consider that the case is manifestly unfounded.
Thank you. We have two more questions, but I think we only have time for one. I say to Gregor Mali, who's asked the next one, we will come back to that at the end. I hope we'll have some time for further questions. But Eva Balina has said, do you think that since criminal claims will not be included in this directive, this could have the perverse effect of increasing criminal SLAPPs against journalists?
The aim is not for that to happen, and actually in the recommendation we recommend member states to decriminalize defamation. Of course, there are other types of cases, SLAPP cases and defamation, but majority are defamation cases, and we are constantly trying to promote also this one.
Okay, Gregor Mali, we'll ask your question. We have a minute to go. Gregor says, I would like to ask Ms. Lindholm if there are any pushbacks from member states or other actors against the directive, and on what grounds are the pushbacks based?
We haven't encountered major pushback. To say that member states adopted their position on this directive unanimously. So all the member states supported it. Their major concern was what I already mentioned. It was the balance between freedom of expression and access to justice. So this was their kind of like biggest concern, but all member states agree that the instrument is needed.
Thank you. Perfect timing. Exactly on your time. Thank you very much, Pia. Excellent presentation, excellent answers. We move on to our next speaker. So our next topic is an overview of SLAPP cases in the EU. And we're delighted to welcome Dirk Voorhoff, who is Professor Emeritus. He's from the Human Rights Institute at Ghent University, and he's a member of the Committee of Experts on Strategic Lawsuits Against Public Participation, which is run by the Council of Europe. So a great expert on SLAPPS. Dirk, welcome. Over to you. You need to unmute your microphone, Dirk, as well.
Thank you, Jonathan. I just need to find out how I come to the next slide. Yeah, I see it here, the slideshow.
You need to make it full. You need to make it full. That's it.
Yeah.
You're there. You're there.
You can see it. Yeah.
Yes.
Okay. Thank you very much also for the invitation. What I would like to do in the next 25 minutes is to make clear that SLAPPS exist. There's still some denial in some countries about the need to do something against it. Secondly, they exist in many different forms. There is an increase of reported cases in Europe in many countries. And finally, also that SLAPPS are harmful for the targets, for the defendants, but also for society as a whole. I try to explain that with support of some slides. There is a steady increase of reported cases. How do we know that? There are no official data because, as Pia also mentioned, there is no notion or concept of SLAPPS yet in the national legal frameworks. So we work with data available from other platforms. Like, for instance, there is a European platform for the promotion and protection of journalists and safety of journalists at the Council of Europe. And their last annual reports indicate an increase of notifications and reports about SLAPPS in different kinds of, in different countries in Europe. They're also aware that this is only the top of the iceberg. It's only a few cases that reach the European platform. And it's only about journalists. Also ECPMF, the European Center of Press and Media Freedom, also have a platform in which they collect data on this issue. But if you go broader, and it's not only media and journalists, also like Pia mentioned, then an organization like CASE, the Coalition Against SLAPPS in Europe, which is a coalition of more than 100 NGOs who have started to make advocacy in order to stop SLAPPS in Europe. And one of their last reports, they mentioned SLAPPS continue to mushroom across Europe, and they have tried to justify this by finding data and reporting about it, and they consider it as one of the most pressing challenges for the universal right to speak and the right to know for the moment. Also Article 19, a London-based freedom of expression NGO, has also published in 2022 a report that confirms that it exists in every country that they had been reporting on the nine countries. More data are available in the big reports and on the website of CASE. Their first very substantiated report is from 2022 in cooperation with University of Amsterdam. They identified about 570 cases over the last years in Europe, and this has grown now over 820 cases in their report 23. So there is an increase of reported cases. Of course, you can raise the question, what is wrong with strategic litigation? It's in academic books, it's in training of lawyers, it's promoted by some official organizations, for instance, to combat inequalities, to combat racism, discrimination, and there's a lot of strategic litigation going on in climate change cases. So there's nothing wrong as such with strategic litigation. The problem is that what we are talking about with SLAPPS, it's an abuse of the judiciary to silence voices that need to be heard in society. It's about intimidation, it's about harassment, it's about creating a culture of fear through litigation. And it is detriment for the public participation on matters of public interest by journalists, by human rights defenders, by academics. So also that the right of the public to be properly informed becomes into danger. It's an abuse of the judiciary, it's a kind of lawfare, and it's aimed at interferences with freedom of expression, which violate Article 10. If you look at the case law of the European Court, the chilling effect is very often an important argument of disproportionate or abusive reaction against the use of freedom of expression and taking part on matters of public interest. So it's vexatious, it's abusive, and it hits something which is crucial in our democracies, which is the open debate. There should not be fear for people, NGOs, journalists to speak out and come forward with criticism. These are reports and data from NGOs, you could say, but for instance, also Columbia University has recently published a report, a global report, that is not only in Europe, but it's global wide, that there is an increase reported about SLAPPS, and they have looked what the tools are to react to it and how different courts in jurisdictions all over the world have or have not the possibilities to do something against SLAPPS. For those who want to have a specific view on the situation in the US with a more parodical interpretation, I have put here the YouTube video of John Oliver, but it contains very interesting information. It's not just NGOs and universities who have rang the alarm bell. I think the first one who really have put the finger on the issue and the importance of SLAPPS was the Commissioner of the Council of Europe, the Human Rights Commissioner, Dunja Mijatovic. In a statement in October 2020, has asked for robust and solid and fast, urgent reaction, because she saw indications that SLAPPS were on the rise and were very detriment for civil society and media freedom. And this statement has been picked up, I could say, in a judgment by the European Court of Human Rights. So we have, as lawyers, a very authoritative reference for the moment, that in a judgment of March 2022, in a case against Russia, the court has referred to the statement by the Human Rights Commissioner, and in its judgment, the court has referred to the awareness about the risks that proceedings instituted with the view of limiting public participation bring for democracy. So the European Court itself, in an unambiguous statement, made clear that risks are a danger for democracy. We need to do something about it. And also other public institutions, the European Commission has now taken initiative. We heard very interesting explanation by Pia about this. The Parliamentary Assembly of the Council of Europe very recently, also a committee and a report, has asked for robust action by the Council of Europe. And there is a draft recommendation in preparation for the Committee of Ministers, not only for the EU, but for the broader group of countries, member states of the European Convention of Human Rights and the Council of Europe. But what are the general characteristics of SLAPP cases? Let me give some additional information. What is it about this increase of reported cases? What is it about cross-border cases? Who are the targets? Who are the slappers? What is the legal basis? And where does it occur? And I will give a few examples at the end if Jonathan still allows me to do it, but I really try to stay within the time limit in respect also for the others. Reported increase. I don't need to give much explanation with this graphic, which is based on the data provided in the very substantial report of case, which is online available, and the increase of reported cases is manifest. There can be no discussion about this. One of the conclusions and the findings of this study is that in about 10% of the cases, we can speak about cases with cross-border effect, where not the claimant and the defendant belong to the same jurisdiction. You could say, well, it's only 10%, so indeed the proposal of directive is only focusing on a small part of SLAPPS, but it's also a very devastating, it's a very harmful type of slapping, because they bring the defendants to much more financial damage, to much more problems in defending themselves in other jurisdictions. The length of the proceedings, the costs is mostly in a country where the costs are much higher than in the own country. So it is a very invasive way, this kind of libel tourism or abuse of forum shopping, in order to irritate and intimidate and harass as much as possible the defendant. So something needs to be done in the first place against those, but nothing will hinder the member states when they implement the directive to make in their own national law the new SLAPP rules also applicable on domestic proceedings, of course. It's a minimum harmonization. Who are the targets? And the targets are mainly media and journalists, but not only media and journalists. A lot of NGOs, activists have suffered from the phenomenon, academics, and also some bloggers, and I would need to mention here in this company also lawyers have been the targets, the victims of SLAPPS, because as human rights defenders, for instance, they had criticized some organizations or politicians. Who is the slapper? According to this more than 800 cases who have been evaluated now, well, it's mostly corporate organizations or the representatives of it, or the CEOs of mostly big enterprises or corporate industrial groups. In some countries, it's very often still politicians and public officials who initiate SLAPPS. And then there are very different other kinds as well. The legal basis can be very different. The main legal basis is defamation, libel, and insult, mostly in civil cases, but in countries where it's still possible under criminal law is used to bring cases before criminal courts, but for instance for defamation. Privacy and breach of protection of personal data is another legal basis which is on the rise in terms of SLAPP. Cybercrime, stalking or harassment, because the claimant has the impression that journalists or NGOs are stalking or harassing them with their criticism or their protest and activities. Sometimes intellectual property rights, because trademarks or copyright protected material is used by an NGO in a video movie in which they criticize, for instance, a big fossil producing company. Protection of trade secrets is also used in this matter. Some journalists have also been harassed with abusive legal claims in order to reveal their sources. Although under European law, journalists have a very strong protection of journalistic sources, so many of these cases are also to be qualified as abusive, and mostly civil indeed, but in some jurisdictions also criminal or administrative lawsuits. Where do they occur? Well, this map, which is also available on the case website, collecting the data, show that those countries who are in red have most reported cases, and the lighter the color, the less reported cases. So you see here, for instance, Poland is a red country where many cases have been reported from, but also many other countries like France, Italy, Serbia, Croatia, Greece, many other countries have, from many other countries, cases have been reported. To start with, Poland, because it's on the top of the list. One example is the newspaper Gazeta Wyborcza, who is critical of the actual government, the actual temporary government now, we must say, and has been targeted with many legal actions because they criticized politicians, officials, with regard to the policy. A lot of investment in terms of legal defense by Gazeta Wyborcza in this regard. We have heard the case about Malta. Everybody knows this background. In France, another example, and the group Socfin Bolloré has introduced many different cases against journalists, but also against lawyers and NGOs who report on human rights violations in palm oil industry and plantages in Africa. In France, there's also a national group on Ce Terra Pas, who is reporting these poursuites bâillons. They have a specific name in France, these SLAPPS in their country, which are also at an alarming level. In the UK, because we are talking about the big Europe, there we are confronted with libel tourism, very high costs of this kind of proceedings, lengthy proceedings. Some law firms have specialized in reputational damage management. And some media are really confronted with this phenomenon. And we have heard the testimony of the legal officer of The Guardian, who made clear that 2 or 3 SLAPP threats or cases are dealt with now by The Guardian. So they had to take extra legal experts instead of journalists in order to defend all these cases or to prevent cases going to court. So it's really a heavy burden on media. An example of a recent judgment at the level of the European Court of Human Rights also shows a clear example of slapping. A former president of Croatia, Mr. Mesic, who was critically reported on an investigative news portal as being involved in corruption activities, with procurement of armed vehicles with Finland. And there was a document of the Finnish public prosecutor on which they relied. They had been in contact, the journalist, with the public prosecutor in Finland. They had reported about this. But Mesic asked immediately that the article would be redrawn. They refused it, and he brought cases. He lost on every level in Croatia because it was well documented. Still he took his case to Strasbourg, where also the European Court said there's no reason to see any problem with this kind of journalism. This is not an intrusion of your privacy or reputation. And there is case law that a high-ranked politician must also be able to cope with some criticism when the journalism is sufficiently founded and responsible, reporting with a factual basis. So this is a case of 2015, which followed until the end of 2013, until there was a judgment by the European Court. And there are many examples of this to give. And then I would like also to give an example from Belgium, because this is also reported on the data provided by case. It's a case about Belgium, and Belgium is said also to have a problem because there are quite some reported cases for such a small country, and they report about a case of a small investigative group of journalists online with limited resources of subscriptions, who have been targeted by a businessman with civil lawsuits, with criminal prosecution, that took many years. And finally, luckily in our West European countries, mostly the defendants win their case, but the fact that it takes so long, that so much money and energy need to be invested to deal with these cases is detriment. And instead of having extra journalists who do the investigative work, and they had to invest about 125,000 euro in the defense of their cases. And in that manner also then the lawyer came, because we are talking here what is the position of lawyers in SLAPP, came into the picture, because he was considered responsible of supporting, assisting the businessman in organizing all these SLAPPs, and the Belgian lawyer was nominated at a certain moment last year as the Bully Lawyer of the Year. He didn't get the prize. There were others that were worse, but it indicates that it is a sensitive point, the assistance of lawyers in manifest cases of abusive litigation, because here also the court at the end came to the conclusion, the Court of Appeal, that it was a form of vexatious and abusive litigation by the businessman. As member of the academic community, I would also like to raise the attention on the fact that also academics are more and more hit by SLAPPs. 3 examples. Wojciech Sadurski is a famous constitutional legal scholar in Europe. He was a professor at the European University Institute in Florence, and he is critical. He was critical, and he's still critical for the actual government in Poland with regard to some, as you all know, measures which have been taken against the impartiality of the judiciary and the Constitutional Court. And he is slapped for that. He needs to defend himself in court cases because politicians and officials have started legal action against him. Another example, in Denmark, a country where they say that they don't have SLAPPs, Stig Markeyer is a professor at Aarhus University. He's an expert in maritime biodiversity. And in an interview in a newspaper, he held the farming sector responsible for the pollution in coastal waters around Denmark. And he was sued in court by the organization of the farming and agriculture organization for defamation. He won his case. He was acquitted after a long period, a long procedure, but it took a lot of energy away and of course also financial costs to defend his case. And in Belgium, the case of Mark van Ranst, he's a professor at Leuven University. He's a top expert in immunology, and he was the advisor of the government in the COVID-19 period. He had several criminal cases against him for charged for defamation by the anti-vax movement because he had criticized the anti-vax movement. So these are examples. There are many more. And an organization like Scholars at Risk is now also collecting data, how academics who take part in public debate, who criticize corporate organizations or public persons are targeted. And the last example I would like to give, because I think it's a very sensitive point, but it's a very important one, is a group of researchers who have published a book about sexual harassment in the world, in academia. And what has happened now is that the book by a very big academic publishing company, Routledge, Taylor and Francis, the book has been redrawn from circulation because Routledge has received, I quote, a series of legal threats from various parties, including from a leading UK law firm. And it looks like that Routledge has taken the book back from circulation because they don't want to be involved in a libel case or a defamation case in the UK. It would cost too much money to defend such a case. So it's silencing precisely. It shows the effect of what sometimes also only the threats of SLAPP can have in such a case. And although there are at the moment 8 persons who came forward with the testimonies of sexual abuse by a person who recognizes himself in a book chapter of the book, it's a kind of a Streisand effect now that plays. It's a very obvious example how even an organization with a lot of financial means, like Routledge Publishers, is intimidated by such a threat of legal action because of defamation. My conclusions...
I'm about to intimidate you and silence you, Dirk, because there are some questions which I would like you to answer before we come to the end. They're coming in more and more. First of all, not a question, but just a remark. You will need to be careful about your map of Cyprus in the future. So there has been a complaint about your representation of Cyprus. But the question which has come in on SLAPPS is, Case talks about this growing number of SLAPPS, but since there isn't a law in place on SLAPPS in the member states, who reports the case? In other words, how do they decide whether it's a SLAPP? Why is it a SLAPP when there's not a law about it? That's really the question.
Yeah, it's also with the question which was already posted to Pia. When do we know when it is a SLAPP? It's a bit vague. Well, there is, of course, already a lot of experience of reported cases, and Case itself has selected a set of criteria in order to help to identify SLAPPs. And the more of these indicators are available, the more there are reasons to qualify something as a SLAPP. So that is what has happened then internally, to look, does it have sufficient characteristics of a SLAPP? And that, for instance, is also what will be done now in recommendation by the Council of Europe. They have proposed 10 indicators to identify a SLAPP, and some have been mentioned by Pia. It's very powerful organizations, politically or economically. It's abusive, with not much perspective that you can win the case. There is an intention to harass and intimidate persons who take part in public participation. That's very important, that it's about expressions, reports, statements which are linked to a matter of public interest. And there are a few more indicators who can help us to identify at this moment what we consider as SLAPPs.
Right, and if I could ask you to be quick, because they're coming in thick and fast, the questions. Ivailo Toskov says, since you mentioned that lawyers can be targets of SLAPPs, do you think also judges can be targets? We have several cases in Bulgaria, the questioner says, where a claimant defendant would initiate a court proceeding against the judge so that the latter will recuse herself from the case in question.
Lawyers certainly, because lawyers take part in public debate. They gave interviews, they write articles, so they can be considered as victims of SLAPPs. With judges, I don't know if it is when judges take part, and they can do that according to their right to freedom of expression under certain limitations. And they take part in public debate on matters of public interest, and they are slapped for that. Then I would say, yes, that they can also be a category who can be attacked, and that it's the intention by the slapper to silence or to harass the judge at issue. Yes, absolutely. It's also what Pia said, it's not a closed category. We see that all kind of persons, also whistleblowers, can be slapped. It's a very broad group of persons, legal persons, who can be the target or the victim of a SLAPP.
Okay, quickly then. Thomas Langer says, hello, are you aware of SLAPP tactics when the slappers threaten and harass the target, a journalist, via social media, Facebook, YouTube, and then these threats are taken up by the followers of the slapper, who follow up with a huge number of aggressive posts and messages, physical threats, and even personal confrontations? Has that been reported in some EU member states?
Absolutely, and it's one of the indicators. I didn't want to go over all 10, but very often legal action which is considered abusive with the intention to harass and intimidate goes together with a smear campaign, with other tactics in order to intimidate and harass, denigrate, and make life difficult for the targets of the SLAPP.
Fine. One last question very quickly. Fotaini Naziri says, good morning from Greece. I have a SLAPP case. Where and how do I report it? I am an attorney. I think they mean, how do they report it? So it's part of the statistics. In other words, I assume is
yes,
what the meaning is.
You can report cases at the website. There is a window where things can be reported, and then of course they will be evaluated if they fulfill the criteria to come into the database of the SLAPP cases reported by the Coalition Against SLAPPs in Europe.
I see there's a question from Christia. I will answer this question. I hope I remember it because actually it's more on the disciplinary side against lawyers. So thank you so much, Dirk. Your time is really up. That's been really excellent. We really thank you. Excellent presentation. We move on now, and I would like to welcome our next speaker, who is Elisabeth Scheuba. Elisabeth is the chair of the CCBE's Access to Justice Committee. She is an Austrian lawyer. So we say welcome to you, Elisabeth, and I will share your slides now. If you can start speaking, and then we will.
Thank you. Thank you, dear Jonathan. Good morning to everybody. It's a great honor and pleasure to be here today. I'm a sole practitioner in Vienna, and I'm used to bring cases to court, as perhaps most of you. And I would like to invite you for the next 25 minutes to come along with me and have a look from the practical side, from the view from the side of a practicing lawyer on the toolbox the Commission is offering us. How will we have? How can we deal with it, and how can we? What new challenges will we have? Will we perhaps face? Jonathan, would you like the next one, please, if it's possible? The next slide, could you? Because I just gave you over. I will first address the lawyers. What? Yeah, sorry. The lawsuits as such. Then we come to the public participation, and then we come to the special instruments. First, let me some words about lawsuits as such. We are all aware, whenever an individual, when the civil rights of an individual are infringed or questioned or disputed, there is no lynch justice. There is no right to take the law into his or her hand. We have the fundamental common consensus and social achievement that the competence and authority to settle controversial civil laws is within the courts. So the instrument made available in principle for to the individual person to bring a case before a court is lawsuits. So lawsuits as such are in fact granting to the individual access to justice and to a court decision, and they start a procedure in the framework of the principle of a fair trial. So as such, lawsuits per se are granting access to justice. But please, next, what can make lawsuits abusive? We already heard it, but in my slide you can see that I highlighted the keywords. The keywords are the aim of the claim, is harassment and silencing of the defendant. And the purpose of the civil proceeding is not gaining access to justice. So we are having two key words, two key terms, the aim and the purpose. So these are, it's quite amazing, because the aim of the claim and the purpose of the proceeding is nothing you can see at the first glance, but they are referring to the attitude and to the mindset, let's say. Next, please, Jonathan. So when we can see again the main purpose, according to what is in our toolbox, the main purpose to prevent or restrict or penalize public participation. We don't have a definition, not yet. We have indicators when the purpose of a proceedings is abusive. And we have there one indicator given, the nature of the claim. It is disproportionate, excessive, or unreasonable. We all know indicators are just giving indications. We have to interpret them. The judges will have to interpret them. And in the very beginning, it will be, I think, for us in practicing law, a big challenge to find out and to advise in what cases is the nature of the claim disproportionate. Yeah, we will by time of we will have decisions of the courts, we will get to know. But at the very beginning, the legal certainty is not that clear. We have another indicator, multiple proceedings. This would be, of course, easier, because this is easier to identify. And then the third one is the part of the claimant, intimidation, harassment, and threats. But as you can see, these are only indicators, and there's not yet a definition. So let's have a look to the role of lawyers. Just next, please. Which lawyers may play in lawsuits. In a normal, let's say, lawsuit, we have lawyers may either defend lawsuits clearly on behalf of the clients, issue on behalf of the clients, and be confronted with lawsuits launched against themselves. We are all possibly defendants. And with reference to the abusive lawsuits, we might either defend lawsuits launched against our clients in an attempt to silence the clients. We can as well be victims of lawsuits launched in an attempt to silence us lawyers, or we can issue lawsuits on behalf of clients, which may turn into SLAPP cases. Next, please, Jonathan, because let's have a side step to lawyers' end. When a lawyer once been given an instruction from a client to abuse court procedures in the way we already heard, then we have to advise the client that the courts cannot be abused in this way. This is based in the lawyer's ethics, and Jonathan will come to this back. It's national domestic law. Let's come to the public participation. Public participation, we have a definition, is any statement expressed, any activity carried out in the exercise. So on any matter of public interest, you already heard it. But what does it mean for us in everyday life? Any statement expressed and any activity carried out is a very, very wide range area covered. We can discuss, of course, on a legal basis whether just tolerating something is an activity or not. But as a principle, I think we have to proceed on the assumption that activity carried out and statement expressed are very, very wide, and on any matter of public interest. And now, John, please go to the next one. What matter of public interest? That's very interesting. How the tool, or not the tool yet, but how public interest is defined in the draft directive. any matter affecting the public to such an extent that the public may legitimately take an interest in. From the practical point of view, we can see at the first glance there's a certain circularity in this definition. How to deal with this? And for me, the really being confronted with everyday life, the big question is, what it isn't under such a definition closely everything of public interest? Even if a private person in a private life, the question how often are you doing your laundry? Once a week, twice a week, 3 times a week? It might affect have environmental effects. So could this be of public interest? And from this question, you can easily see, I personally see that there is a lack of reference to the importance of the matter, to the welfare of the general public. Because in our globalized world, exchanging even matters of digestion or whatsoever, it would be easily to be argued that in public interest is nearly everything. Please, next. The interesting role is public participation by lawyers. How does this have any impact on our rights? Because let's face it, being a lawyer and acting either on behalf of our clients or for ourselves, any statement expressed, any activity carried out on any matter as affecting the public to such an extent and so on, it's all we are doing, either representing on behalf of our clients or in some other way making public participation. In this connection, the question arises as to the impact. Will we either benefit from the measures against SLAPPS when we are a victim of a lawsuit launched in an attempt to silence lawyers themselves? Presumably, yes. But on the other hand, will our practice of our profession, especially in the domestic procedural rights, will this have any impact on it? For instance, according to the Austrian procedural law, we are entitled to represent the parties. It's in the domestic procedural rights. Given the public participation by laws when we are acting on behalf of our clients, will this new instrument have an impact on this procedural role? I don't know, but please, next. It is a big question for me. Jonathan, please, next. Yes, thank you. But the key question for me, for everyday life, is how to identify SLAPP in everyday life. Yeah. You remember, as I said before, we have no definition. So let's start with an example, as I give a very simple one. The journals D questions in a publication the effectiveness of a medical product C. Let's say it's a vaccine against COVID-19. Yeah, that would be a very controversial question. And the producer C of this vaccine launches lawsuits against journals D for defamation, slander, fake news. Next, please. So what kind of questions will have to be checked? Is the producer's proceedings brought in relation to journalists' public participation fully or partially unfounded? That's the first question. Is the main purpose of the producer's court proceedings to prevent, restrict, or, sorry for the typing mistake, not personalize, but to penalize participation of journalists? And third, of course, are there any indications for such a purpose to be seen? Because we have no definition, we have to refer to purposes. Is the nature of this claim unreasonable, disproportionate? Let's just take unreasonable. The judge will have to decide unreasonable. Unreasonable in relation to what? Unreasonable meaning the relation between the claim in dispute and the costs caused. Unreasonable from the side of the defendant. Or does unreasonable mean still simply not logical. It's just an example, but I would like to show you that we have a lot of questions which are due to the fact that we have a lack of a definition of SLAPP. Next, please. So the questions in practice to be answered to identify SLAPP. Is the claim manifestly unfounded? And I think this is the relatively easiest question, because we will find the answer in the applicable substantive law. The applicable substantive law should give a clear answer. Is the claim manifestly unfounded? But the second one, is the aim of the claim abusive? Or are the claimant's intention and attitudes covered by legitimate interest to pursue her rights infringed by the defendant? And there we have no definition, we have just indication. And we have this third question: is the main purpose of the proceeding abusive? Is it or is it the purpose to gain access to justice? But first, resume, please, Jonathan, for the lawyer's perspective. Please, Jonathan, the next. Yes, it is no doubt about SLAPPs are an abuse which must be stopped. The question to be answered to identify SLAPP are difficult, because by now we have only indicators given to enable the courts to draw conclusions on the claimant's intention to either gain access to justice by their court proceedings or to abuse claim for silencing the defendants. Definition we have none. And the possible impact of the measures against SLAPP on the domestic procedural rights of our profession acting on behalf of the clients are not yet clear and are not yet, we will have to examine and have a look to it. Please, next. How SLAPP cases have been tackled by now. We have already provided instruments in the many legal systems of the member states to deal with tactics and inadequate behavior, disciplinary claimants. Please, next. But of course, please, Jonathan, next. The civil procedures, they differ substantially. And we don't have not a common approach in our members, but the question for me is, will the implementation of the directive be the adequate way to deal with the SLAPP cases? And is the best way? Perhaps yes. Let's come to the draft directive, the legal basis, as already mentioned before. Please, Jonathan, would you please? Yeah, we have the Article 81 of the Treaty on Function of Europe, traditional cooperation in civil matters having cross-border implication, and we need really still to consider carefully and examine carefully whether this article would provide sufficient basis for the legislative measure. We already heard, Pia, thanks to you, saying that there is a clear balance to find. Please, next step. We always also have to have a look at the principle of subsidiarity. It still needs to be examined in detail. We all know this. I leave it by this. Just please to the next. So the first question, the main question, and we addressed it before. I'm very grateful for this. We have a broad definition, and it is explained that the specifics of SLAPPs make it necessary to have such a broad definition. However, if you go through it from the practical point of view, act of public participation, we mentioned already before, concerning a matter of public interest, already mentioned before, court proceedings are initiated, is relevant for more than one member state. In a globalized world, I can hardly think of any case which would not be relevant for more than one member state. So the question is, does this broad definition perhaps undermine each member state's national competence in procedure law? Does this open the door for new proceedings sui generis on an EU level? And is it disproportional or inconsistent with the subsidiarity? And at the end, of course, will it cover all domestic proceedings in which public participation is facing an opposing party? The question is still open, but it might be that we are in favor of this, but we should be aware that this could be the consequence with such a broad definition. Next one, please. Last one, I would like to come to some of the key pillars, as Pia has mentioned. Yes, that's right. Here is the center of the focus of to put on to find the right balance between tackling SLAPP, anti-SLAPP measures necessary, tools necessary, appropriate on the one hand, and access to justice. And seen from this measure, third-party intervention, we have in the many domestic civil procedural laws, we have already this instrument, but we need to have it to some extent coherent with the already existing instruments. Security of costs is one really access to justice. It's really putting a high level to access to justice, and it makes it even more difficult. It is appropriate to have security of costs for SLAPP cases, but it is difficult to find the balance for those claimants who have, of course, justified claims. And early dismissal, I think, is one of the detrimental instruments to access to justice. So we will need to be, as Pia mentioned before, very careful to find the balance. And the last one, a burden of proof. Of course, we have a reversal suggested, which is, from the practical point of view, very difficult, because it comes to a result as if proving of being not guilty. Please, next. So I think the good and the balance should be found. We need to tackle SLAPP. Yes, it's abusive, but it should not limit or restrict the access to justice, and it should not result into denial of justice for those claimants whose rights have been infringed by defamation, slander, or facts. So last slide, please, Jonathan, then we'll come to the end. The SLAPPs are abused, it must be stopped, but there is no definition of SLAPP proposed now. And this is, I think, the major, for me as a legal sole practitioner, and from the practical point of view, is a big deficit by now. We don't have a definition of SLAPP. We need a definition of SLAPP given the far-going instruments to tackle SLAPP, and given the fact that we need a balance between fair trial and access to justice on the one hand, and tackling SLAPP. Thank you very much.
Thank you so much, Elisabeth. Excellent presentation, and also perfectly within time. We will see now that you have yielded a number of questions. So in the time remaining, please, if you could answer the questions. Well, the first actually is a double question from Juha Regelin, who asks, what do you think the national bar's role should be to prevent or control SLAPPs, and should the bars have any role at all?
I think, Jonathan, this question refers to your presentation.
I'm happy also to deal with it. Yes, it deals with the ethics part of it, and I suppose it also deals with the training part. I mean, I could certainly answer that. Well, maybe yes. I mean, I will deal with the ethics and the training, and those are two roles of the bars. If there's anything you want to add beyond that, Elisabeth.
Since the bars play a very important role, of course, because it is part of our self-understanding role. Lawyers are resorting to their bars, and that is very important. But however, there are two pairs of shoes actually. The role of the bars on the one hand, and I was referring to the court procedure where we all are acting and actors.
Yeah, indeed. And Alina Vosiliuti says, what are the best practices in decisions when a court identifies the claims as SLAPPS. And actually, Elisabeth, if you would like, I am happy to broaden this out also to Dirk and to Pia, if they would like to help to answer this question about what are best practices and decisions when a court identifies a claim as a SLAPP. I don't know whether there's anything you want to say first.
Yeah, no, I just wanted to make reference to what Dirk said before, because you we heard the case of STP message, and I think was a very good example how it worked within a court, that they found the claim as unfounded, and it was a correct decision. It was even confirmed within the European level. So I think the already existing instruments they have, despite the fact that they are not explicitly mentioning SLAPP, but they have already the power to get hold of SLAPP.
Dirk, I see you've appeared on screen. Do you want to add anything to that?
I would like to the question on what are some good practices. Well, first of all, I mentioned that luckily in many countries the defendants win their cases. That's already, of course, a very important statement in application of Article 10 case law of the Strasbourg Court. Very good. Other courts have chosen for accelerated proceedings within the possibilities of their procedural rules. Very good. Other courts have convicted the claimant for abusive or vexatious litigation in application of the general rules of abuse of procedure, sometimes imposing a fine when national law is providing it, or giving a special award of damages to the defendant. So there are some examples, but the problem is that there are so many SLAPPs where it doesn't happen, and that the judiciary is very reluctant because they don't have clear instruments to apply these good practices in many countries what I just have mentioned. And therefore, a harmonization, I think, is needed at the level of the EU or the Council of Europe. And I think also if the lawyers and the law organizations would be able to contribute on more awareness on the issue, it would also help, and to make that those law firms and lawyers who really abuse, and there are so many examples of this, have abused the judiciary in one or another way, can get a reaction from their ethical bodies or bar and law societies. I think that also would be a step that the bar and law society show that they watch these kind of developments.
Elisabeth, you want to speak again, please?
Yeah, please. That's a very thin ice, because I fully agree that lawyers should in no way contribute or assist in a SLAPP case. However, if you just alleging that the lawyer of the opposing party is under SLAPP suspicion, this gives you easily the possibility to kick him out or kick her out. So it is a very thin ice, because the lawyers, as they are part of the public participation in any lawsuit, they might be threatened by even the suspicion of having themselves somehow abused the court, and then it would be easy to kick the lawyer representing the opposing party out of the lawsuit just by alleging it is SLAPP.
I can see we're getting to the heart of the balance here. Dirk wants to reply. We have a couple of minutes, so we can, and there are no further questions at this stage. Dirk, do you want to say something further?
See the thin ice. For instance, when a court has decided that court proceedings were abusive and vexatious, then you have an indication maybe to start doing something against a lawyer who has, even according to the court, abused the judiciary. That doesn't need to be a final finding, but this is not thin ice. I think then you have a judgment.
But it is thin ice as long as we don't have any definition of SLAPP. If we just have in indicators, giving a clue, giving to interpret, it is very difficult to really get hold of SLAPP, to identify it, and we need so much to identify it clearly. but without any question marks and without any suspicions. We need a clear definition.
Sorry,
Pierre,
if I
you've come
Look
on
at the
screen. Pierre,
yeah.
I'm going to give the final word to Pierre,
Yeah.
who's come on screen. Do you want to say something, Pierre?
Yes, I just wanted to say that we think that on the basis of the facts of the case, it is for the courts. It is a court which examines the case and draws a conclusion. So it's on a case-by-case basis in the end. And I don't think it's possible to give to the court a closed definition, which it should then apply only this is an abusive SLAPP, and then some other indicators, okay, that is not a SLAPP. So we concluded this, and also with the member states, and we were obliged to conclude this.
Fine, thank you. Thank you, thank you, thank you. A very good debate, which goes to the heart of how, according to the new directive, the court will make the decision as to whether it's a SLAPP based on what will be in the directive. Very good. Thank you so much, Elisabeth, and thank you for raising this debate, and thank you also for the questioners. We now come to the final session. I shall introduce myself because I am the speaker in the final session. Just by way of background to this, I am also a lawyer, and I am a former Secretary General of the Council of Bars and Law Societies of Europe. I stopped doing that in 2015. I will be speaking about the European Commission's recommendation on SLAPP and its impact on lawyers' ethics. And we've had quite a bit of discussion about this already, and so this will be developing it further. Pia, right at the very start, mentioned this. Elisabeth mentioned this as well. This is the European Commission's recommendation, which came out at the same time as the draft directive was published in April of last year. I've put there the link so that you can find it when the slides are put on screen. And the recommendation had a number of recommendations to the member state. It's not binding, it is a recommendation, it is urging and encouraging. One of the parts of the recommendation was on lawyers' ethics, and it's on screen here. And basically, it's saying that member states should take appropriate measures to ensure that the deontological rules that govern the conduct of legal professions and the disciplinary sanctions for violations of those rules consider and include appropriate measures to discourage SLAPPs. So I noticed that it's both the ethical rules and the disciplinary sanctions. That comes back to the question which has already been put about discipline, which we'll come back to. And member states should encourage self-regulatory bodies and associations of legal professionals to align their deontological standards, including their codes of conduct, with this recommendation. And then there's a separate sentence about appropriate awareness raising and training, which is also recommended. I'm going to deal with this in two parts. First, to talk about the ethical side of it, and second, to talk about the training. And on the ethical side of it, this raises for lawyers, and Elisabeth has given some indication of this already, a big challenge. And the big challenge is the fact that we are used to doing what our clients want, provided it's lawful. So that, you know, clients' interests come first, and we are devoted to our clients' interests. But SLAPPS is one of those issues which raises issues of justice, whether something is right or wrong, without it necessarily being unlawful. It's perfectly lawful to bring a defamation suit. So how does a lawyer balance what the clients want and what certainly extremely important stakeholders like the European Commission consider to be in the interests of justice. And that is a very difficult question for lawyers. Now, the CCBE has put in a response to the recommendation. And this is what the CCBE response said. It said, the CCBE highlights that when carrying out their duties, lawyers shall respect principles of dignity, conscience, integrity, and loyalty. These principles are prescribed in the CCBE Code of Conduct and the Charter of Core Principles, and I'm going to come to that in a bit more detail in a moment, as well as in national ethical rules. Now, this is a very important sentence. This competence of national bars and law societies is considered as one of the utmost important cornerstones of self-regulation of the legal profession and should therefore be respected. And again, Pia talked about this when she talked about the Parliament and its amendment. And we know that both the Commission and the Parliament are very keen to get at the ethical rules of lawyers, but the Commission and the Parliament is well aware that one of the most important cornerstones of the rule of law is the self-regulation of the legal profession. There's this tension between the stakeholders wanting to tell lawyers what to do, but recognizing that in a free state governed by the rule of law, lawyers should not be dictated by the state as to what their ethics are. And it's a kind of a tension. So SLAPPS raises various tensions, as we have already seen in our previous discussion. Now, I'm now going to come to what the CCBE code says about this tension, and it's a very interesting statement. And so again, it's all this, you don't have to write any of this down, it's all on the slides, you can look it all up, and it'll be on the website. So the lawyer's role, this is what the CCBE says the lawyer's role is, whether by an individual, retained by an individual, a corporation, or the state. It's a threefold role. It's as the client's trusted advisor, so you do what the client wants, basically, as a professional respected by third parties, the courts and outsiders, and as an indispensable participant in the fair administration of justice. So we're not just the client's trusted advisor. The CCBE recognizes we are also a participant in the fair administration of justice. And then it goes on in one of the principles to say that some of the most delicate problems of professional conduct arise from the interaction between loyalty to the client and these other principles which set out a lawyer's wider duties: dignity and honor, respect towards professional colleagues, and respect for the rule of law and the fair administration of justice. So there's a recognized tension there between the client's interest and the interests of justice. The top principle here, I'm continuing with the code of conduct, is really just a repeat that lawyers are participants in the fair administration of justice. Sometimes they're called officers of the court or ministers of justice. But this is the crucial sentence, which also appears in the CCBE code, which is saying the handling of this apparent conflict between the interests of the client and the interests of justice presents delicate problems that the lawyer is professionally trained to solve. The lawyer is entitled to look to his or her bar association for assistance with such problems. And I pause here because a question which I'm coming to, which we didn't fully answer, was what is the role of the bar in all of SLAPPS? And so what the CCBE is suggesting is that some of these great tensions about my client wants to sue this journalist, taking a defamation claim is perfectly lawful and proper and clients can do it. But on the other hand, is this an abuse of litigation? Should I be doing this? The CCBE suggests that the lawyer is entitled to look to the Bar Association for assistance. But in the last analysis, and this is the key statement, the lawyer can only successfully represent his or her client if the lawyer can be relied on by the courts and by third parties as a trusted intermediary and as a participant in the fair administration of justice. Now, it doesn't say it exactly bluntly, but I take that to mean that in the final analysis, the lawyer's duty is to justice. So that is where you can get guidance on these issues from the CCBE. Now, there has been some research into bar rules at the time when the recommendation was issued. No bar in the EU has specific reference to SLAPPS in its code of conduct. Of course, that may change in the future, given the recommendation is talking about alignment, given that the Council of Europe is talking about alignment. We wait to see whether this European Parliament amendment that Pia mentioned, whether that will come into be in the final version of the directive. Nearly all the bars had some reference to what Elisabeth was talking about, how a lawyer should behave in the face of being asked to conduct abusive, intimidatory, or unmerited litigation. 8 had clear reference to such conduct, saying that, pursuing claims with undue harshness to enforce the client's claim is not allowed. And 6 had potential references referring to what the CCBE said in its own response to the recommendation, that lawyers must always uphold the principles of dignity, righteousness, and discretion. And there was only one which had no reference at all. And I'm sure that all bars are reflecting on the recommendation and what they should do in the future. That's regarding ethics, and obviously this is a very contested area. I can tell you that at both national and international level, there is a huge debate going on about how you resolve this tension between clients' interests and justice interests. SLAPP is only just one example of this. It happens climate change raises rather similar questions in very different circumstances. If people want to do some things lawful but which damage the climate in the future. There in cases of sexual harassment, where employers take out non-disclosure agreements, in tax avoidance as to whether lawyers should zealously advise their clients how to lawfully avoid paying taxes. These are all really, really difficult questions which are being raised, and SLAPPS is one illustration of those. Regarding training, which I said that I would mention, there are 2 paragraphs about training from the recommendation. First of all, member states should support training opportunities on SLAPPS for legal professionals such as judiciary, judicial staff, qualified lawyers. The focus of training should lie on building expertise to detect SLAPPS and to react appropriately. And then member states should encourage associations of legal professionals, that's bars, and legal training providers to offer training on how to deal with SLAPPS. And legal practitioners and their bars should be involved in the development, organization, and so on of that training. Well, you might say that today is a classic example where we are already complying with the recommendation because we're putting on training about SLAPPS, and that's indeed true. Although if you look at what the recommendation says about the content of the training, we're not quite complying. But that is, I think, completely fair, because at this stage, the directive is not a directive, it's a draft directive. And we're giving an introduction to lawyers about what the directive will look like, which seems a very useful thing to do. But once the directive is in force, this is what the Commission in its recommendation expects lawyers to be talked about. So it's the EU Charter of Fundamental Rights, the European Convention on Human Rights. That's obvious, because SLAPPS are a balance, as we've heard in the debate which has just taken place, between freedom of expression and the right to protect your own reputation. The training should include practical guidance on how to apply EU law, national law, the Court of Justice and the Court of Human Rights, procedural safeguards against SLAPPS. We've talked quite a bit about that today. Obligations for member states under GDPR to reconcile the protection of personal data with the right to freedom of expression. And then there's a final sentence which says that member states should consider embedding such training in training on freedom of expression and legal ethics. This is my last slide. I've just put here, and again, it'll be on the slides on the website. These are the two positions of the CCBE on SLAPPS. What first is the very early one, which was a general position on SLAPPS before the directive was published, but when it was being mooted. But the second one down is the CC position on the draft directive and also on the recommendation. I've quoted from its from what it said about the directive. So that is all I wanted to say. I will now come to the questions which have been asked. Some of them were outstanding. And again, I call on Elisabeth, Dirk, and Pia to support me in anything. So please, if you want to speak, the three speakers, you do so. So first of all, from Christia Papakleovoulou, who says, what about disciplinary actions or complaints taken against lawyers? Shouldn't the directive expand to include these? Well, I think we've more or less answered that. So disciplinary action, like ethics, is a national competence and is, as I see Elisabeth nodding, jealously guarded by the bars. We would really, really be opposed to anything about discipline or ethics being included in the directive. Even Pia mentioned the Parliament one, and as she said, it was very softly worded, saying, I forget the exact words, bars should consider, or member states should consider encouraging bars, I forget the exact words. And so that's because, you know, really, this is an important part of the rule of law. The ethics and discipline of lawyers are bars preserved. But I imagine all bars are getting the message from the Commission and the Parliament about what needs to be done about ethics to ensure that they are compliant with the directive when it comes out. Then Juha Regelin, as we've already mentioned, said, what do we think the national bar's role should be to prevent or to control SLAPPs? So we've seen already in what I've said a number of roles for bars. So clearly the bars are strongly encouraged to align their ethical codes. Number two, bars, according to the CCBE's own charter and code of conduct, are invited to assist lawyers with some of these difficult questions. You know, what is abusive? What goes too far? What is going beyond my ethical duty to the client in this particular case? And then bars have a role in training, as the recommendation said. So bars should really be taking action to, once the directive is in place, to make sure that their lawyers are trained. And I'm sure there will be many opportunities for training. So that would be my answer to Juha's question. There are some more, there's one more question here, and I think this is not for me, so I'm going to look to my expert speakers from Ulrike Zeller. Is it planned that there are legal remedies to the court decision that a lawsuit is a SLAPP? Now, I take that to mean that we've heard before, the court will decide whether it's a SLAPP. And we've heard from Elisabeth that some lawyers will not agree that this is a SLAPP. And so will there be a remedy that will enable the side which is decided it is a SLAPP to question this? I mean, I'm sure the answer is yes, but I don't know whether Pia or Dirk would like to. Oh, Elisabeth, excuse me. Elisabeth, you've got your hand up, please.
Yeah, no, I just wanted to make a short footnote. That the question whether the case is a SLAPP case is always, to my understanding, the first question in order to, on the basis of the answer to this question, then you can take the tools. Meaning, if you have an early dismissal first, then you have to decide it's a SLAPP case. And right now there's a discussion ongoing whether the early dismissal of a SLAPP case should be allowed, there should be allowed appeal or not. This was one of the, in the CCBE position, we raised the question, we should, the audiatur et altera pars, the other one should at least be heard, and the claimant, and it should be brought to the next instance of court. But right now, as far as I can see, it was not yet in the Commission's draft directive. Thank you.
Pia, do you want to speak?
Yes, maybe just to mention that actually we have a specific provision on appeal concerning early dismissal, that decision refusing or granting early dismissal will be subject to appeal. But of course, this is more a declaratory regarding early dismissal, because otherwise in court proceedings, after the court has decided, it's subject to normal national rules concerning appeal. So the national rules will apply regarding appeal.
Sorry, as far as I know, in this Article 9, where there are early dismissal, it's not yet the appeal. I understood that we are in the trial.
Article 13. It's Article 13, okay, which is appeal. Yes.
Yeah, but directly with the early dismissal, it's not mentioned, right? Yeah.
No, it's a separate article on granting or refusing early dismissal is subject to appeal.
Thank you, Pia. Thank you. I don't know, Dirk, whether you want to add anything to that, or that's all.
I would add that in the draft recommendation for the Council of Europe, it is also, of course, mentioned that there is a right of appeal, but the appeal possibility is very often a part of the slapping technique to prolong the process and to irritate longer and intimidate the target. So there, the question is that the appeals should be dealt with in an accelerated way, also in order to reduce as much as possible the negative effect. But of a right of appeal, of course, there's no discussion about that. This remains unrestricted.
Fine. I see no further questions. We are 4 minutes from the end of time, so I propose that we draw to a close. I would like, first of all, to thank the audience very much for your very interesting questions, which, as you can see, provoke much discussion. And I'd like to thank very much indeed our 3 speakers, Pia, Dirk, and Elisabeth. Excellent presentations. You can see in the chat. Thank you very much for all your very nice comments. Great praise for you all. So thank you very much indeed. Thank you to our participants, and we hope that we will see you yet again at another of our trainings. Thank you very much, everybody, and goodbye.